This courtroom hearing begins like a normal plea discussion, but quickly turns into a tense and uncomfortable exchange. The defendant, facing charges of aggravated assault and resisting a police officer, claims the judge threatened him with jail time. In reality, the judge was simply explaining the legal consequences of the charges. Still, the accusation shifts the tone of the hearing. As his lawyer works to secure a plea agreement and clarify bond conditions, the judge calmly explains the situation, including why different judges are involved due to separate jurisdictions. Everything seems on track, until the defendant continues making inconsistent statements. After being given time to consult with his attorney, he decides to plead guilty. But moments later, he starts describing the incident in a way that sounds like self-defense, even admitting he bit someone during the altercation. His own words begin to complicate the plea he just entered. Sensing the confusion, his lawyer requests an adjournment to properly advise him. What could have been a straightforward resolution suddenly becomes uncertain, proving how quickly things can spiral in a courtroom when emotions and mixed messages take over.
Mr. Hampton has entered into an agreement with the people, and I'd like to enter that into the record. Your Honor, is it possible to enter into both today, to address both cases today on the record?
That file is not in the courtroom.
Oh, okay, got it.
But I can give you the bill deed that you answered.
Oh, sorry.
But I don't believe it's.
What? Okay. Talking about bond.
All right, we'll just address it.
Case. That's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete, and that is currently set for exam.
So over there is Ann, right?
Yes.
You know Ann?
Yes.
Okay. So if you had this, that may work out where we could like get rid of 2 cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Ann.
Thank you very much, Your Honor.
You're welcome.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond and request that a condition, specifically the home confinement tether, be reconsidered.
Okay, I'll get to that maybe at some point.
Good, thank you. Yeah.
Right now, I'm trying to get these pleas done.
Thank you.
So my understanding is he's going to plead to count in case ending in 1596. He's going to plead to count 2.
Yes.
Correct? With count 1 being dismissed. That's going to be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, count 1, the resisting and obstructing, would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement.
That's right.
May I have the defendant sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yep.
State your name.
Brandon Hampton.
And man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one, in the case ending in 1596, is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mm-hmm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it says court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Balvo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we're just talking about with Judge Balvo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti in Ypsi City of Ypsilanti. I'm sorry, Ann Arbor Township. Okay. So they occurred in two separate jurisdictions. Okay. That's why you have two separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay. You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to Valvo as well.
It will get there. It just can't go directly that way.
Okay.
Okay.
For sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay. All right. Any other questions you have?
Just the one about bond, but
Yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
yeah,
Okay. So to the charge of aggravated assault, how do you plead?
guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right. You signed an advice of rights form, correct?
Yeah.
Do you have any questions regarding any of those rights?
No.
All right. You see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yeah.
All right. Were you on probation at the time of these offenses?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
All right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
Mr. Hampton, so,
Tell you what, why don't we pass the matter? Maybe you can talk to him and we'll give this another shot today if we're comfortable with it. Otherwise, the court may not be comfortable with it, and we might just blow all of this up and it'll just have to happen another way.
thank you.
But I'll give you versus Hampton. We're in the middle of taking a plea. And so I stated the terms on the record. And Mr. Hampton, I'm going to ask you a couple questions again. Then what's been stated here today on the record to get you to plead to these charges?
No.
Has anybody threatened you or coerced you in any way to get you to plead?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you're guilty of these offenses?
Yes.
All right, we'll start with case 1596. Paperwork, so. Okay, Mr. Hampton, on the date of August 29, 2024, at Washtenaw Community College in Ann Arbor Township, Washtenaw County, State of Michigan, do you recall what happened on that date regarding a Vladimir, is it Parahorov?
I don't know, Your Honor.
All right, did you get into a fight with somebody?
Oh, I know what happened. I don't know what his name is. It sounded like.
Okay, why don't you tell me what happened then?
Oh, I was trying to take a shower, Your Honor.
Okay, and then what occurred?
When I was in the locker room, he had pushed me up against the wall, hit me in my head, and threw me on the ground. And then broke in my property.
Okay, but before that, did you do anything before that?
No,
Okay.
it wasn't until there were 4 people on top of me and I was fearing for my life that I bit him, Your Honor.
Okay, so here's what happens. I can see the way that this plea's going. It's not gonna work. So if you guys want to change, I'm not suggesting if you guys want to change things to a no contest. If you want to do whatever, what I will do is I'm back up at 1. I'll call it back up at 1. I think everybody's still going to be here. So, and give you a chance to talk with them, decide whether or not you want to do no contest, please explain what a no contest, go through all of that with them, and then see if we can get this done.
Thank you very, very much, Your Honor. Appreciate it. Thank you.
This is a prime example for me of no good deed goes unpunished. All right, so we'll call it back up at that point. Quarter past these matters again. All right.
We actually, based on the most recent conversation with my client, I will actually seek to adjourn this case for to further advise my client on the offer.
All right.
For the shortest adjournment possible.
February 13th. Both matters.
Thank you very much, Your Honor.
Both matters? Well, that's true. What are we doing with, well, when is the exam set?
Tuesday.
Yes, so apologies. We can see, I'd be happy to stick to adjourn that, the exam or for the other case.
Well, you're gonna need a step on the exam.
Yes.
But I only took it because there was gonna be a plea. When do you want the other one adjourned to?
When is the soonest?
I'll set this, I'll adjourn the
After the
1596. I'll adjourn 1596 to February 6th. The other one is stay on track for a preliminary examination. I understand that people are not going to have the witnesses available, or you need a stipulation to adjourn that out. Okay.
Thank you, Your Honor.
This courtroom hearing begins with the kind of tension you can feel before anyone even raises their voice. A defendant stands before Judge Simpson facing serious charges, aggravated assault and resisting a police officer. These are not minor allegations. The consequences on the table include potential jail time, probation terms, and long-term impact on his record. A plea agreement is being discussed, and it appears that both sides are trying to move toward a resolution. But almost immediately, the tone shifts. The defendant claims that the judge previously threatened him with jail time. It's a bold accusation to make in open court. The room tightens. The judge calmly responds, clarifying that explaining legal consequences is not a threat, it is a required part of the process. When a judge outlines what could happen if someone is convicted, that's not intimidation. That's transparency. Still, the defendant seems convinced that he was pressured. His attorney attempts to regain control of the moment. The lawyer discusses a plea agreement that could potentially resolve two separate cases. There is also a request to reconsider a bond condition. From a legal standpoint, this is standard procedure. Negotiations happen. Conditions get reviewed. Judges listen. It's how the system functions. Judge Simpson explains why two different judges are involved. The offenses occurred in separate jurisdictions. That means separate authority, separate courtrooms, separate oversight. It's procedural, nothing unusual. But instead of focusing on the explanation, the defendant returns to his earlier claim. He insists, again, that he felt threatened with jail time if he didn't plead guilty. The judge remains steady, calm, direct. There is no visible frustration, even though the accusation is serious. He makes it clear that no one is forcing a plea. A plea must be voluntary. If the defendant does not feel comfortable, the agreement can be withdrawn. In fact, the judge pauses the hearing to allow the defendant to consult privately with his lawyer. That pause is important. It protects the defendant's rights. It ensures that whatever decision is made cannot later be blamed on confusion. After speaking with his attorney, the defendant returns with a decision. He says he wants to plead guilty. For a moment, it feels like the hearing is back on track. The judge begins the formal plea process, asking the standard questions. Do you understand the charges? Do you understand the rights you are giving up? Are you entering this plea voluntarily? The defendant answers yes. Then something unexpected happens. As he begins describing the incident, he adds details that complicate everything. He claims he acted in self-defense. He explains that during the altercation, he bit someone. He frames the situation as if he was reacting to protect himself. The more he talks, the more it sounds like justification rather than a clear admission of guilt. And that creates a legal problem. A guilty plea requires a factual basis. It requires the defendant to admit to the elements of the crime without contradiction. When someone pleads guilty but then describes events in a way that suggests they were justified, the plea becomes unstable. It opens the door to confusion. It raises questions about whether the admission is genuine. His attorney immediately senses the danger. Every extra word increases the risk that the plea agreement could collapse. What may have been a negotiated outcome with reduced consequences could disappear if the court believes the defendant does not fully accept responsibility. Judge Simpson listens carefully. He does not interrupt aggressively. He allows the defendant to speak, but the tension is visible in the structure of the conversation. The court cannot accept a plea built on conflicting statements. The defense attorney steps in and requests an adjournment. More time is needed. More discussion is required. The lawyer needs to explain to his client how serious these inconsistencies are. Once something is said on the record, it cannot simply be erased. What makes this hearing so striking is not yelling or dramatic outbursts. It's the slow unraveling. The repeated return to the idea of being threatened. The inability to separate legal explanation from personal perception. The decision to add unnecessary details at the most critical moment. Throughout it all, Judge Simpson maintains composure. There is firmness when required, but no visible hostility. He reiterates that the court's role is to ensure fairness and clarity. The defendant has rights. He has choices. But those choices carry consequences. The hearing becomes a powerful example of how communication, especially in a courtroom, must be precise. Words matter. Timing matters. Understanding the process matters. A plea deal is not just a formality. It is a legal admission with lasting impact. When defendants argue with the structure instead of working within it, they often harm their own position. When they contradict themselves during a plea, they risk losing negotiated outcomes. When they misinterpret procedural explanations as personal threats, it shifts focus away from resolution and toward conflict. By the time the adjournment is granted, the situation feels heavier than when it began. What could have been a straightforward plea has become uncertain. The defendant had an opportunity to resolve two cases. Instead, confusion now clouds the outcome. This hearing serves as a reminder of how quickly momentum can change in court. A calm explanation can be mistaken for pressure. A simple admission can turn into a contradiction. A negotiated agreement can unravel in minutes. In the end, the most striking element is the contrast between the judge's steady approach and the defendant's inconsistent responses. One side is focused on procedure and clarity. The other appears caught between frustration and uncertainty. And sometimes, in a courtroom, that difference is everything.